Welcome everybody to Law and Crime Daily. I'm Jesse Weber and thanks for joining us. Legal teams were in an Idaho courtroom Friday tackling 6 motions in the case of Bryan Kohberger. Now, police in Moscow, Idaho say that Bryan Kohberger entered a rented home near the University of Idaho last November and stabbed 4 college students to death. Kaylee Gonsalves, Madison Mogan, Zana Kernodle, and Ethan Chapin all died from their wounds. Kohberger was a doctoral student at nearby Washington State University. Police collected trash from Kohberger's parents' home in Pennsylvania, where he was spending Christmas break, and used a DNA sample to link him to the sheath of a knife found in one of the bedrooms. The defense team want access to all the profiles that were uploaded to a DNA database. That would give them the names of other people who were a potential match and any unknown male profiles as well. The defense also requested any of the communications about the testing and information about any issues with the lab that did the testing. During Friday's hearing, the judge allowed the defense to call witnesses, including a criminal defense attorney with a specialization in DNA, a preeminent expert, and he testified about the importance of DNA and knowing how it was collected.
That the minimum practice standard is that the attorney must obtain discovery of the scientific testing of an evidence sample. And that, particularly so in a capital case, and particularly where we're talking about an environmental sample of trace DNA, it's absolutely crucial to get that discovery, because then that informs the scope of the investigation, the experts to hire, and what have you. Now, also with respect to forensic genealogy, it's important not to separate this out into all these different components. It is, you have the S&P testing, and then you also have the development of these family trees through database searching. This is all part of the same testing and experiment. They go really hand in hand, and you can't unravel them. They really have to be considered together as a single cord of different strands and experiment, because the attorney needs to know how these family trees have been developed, because we're talking now about trial issues, and the government is introducing the STR profile. They have to introduce statistics that explain the significance of any STR match that the government is identifying as central to its case. And so the defense must investigate ways to cross-examine those statistics and the rarity of that match that the government is attaching great significance to.
Okay, let's talk about this. I'm joined right now by my legal analyst, my co-host, Brian Buckmeyer, Terry Austin. Brian, I'll start with you. I don't think I've ever seen an attorney call another attorney to the stand to explain why evidence is so important that that team needs access to it, but he is a specialist. He is a specialist in DNA. Do you think it was wise to bring him, and do you think it ultimately is going to convince the judge?
I would actually disagree with you a little bit there, because I would say that I'm a specialist in DNA. He, at one point, was considered the national standard for excellence in forensic litigation. He's forgotten more about DNA than I will probably ever learn.
Right.
And so to have him on, because I remember before this, I was like, why would you do this? One attorney to explain what another attorney can do, but no, he is there. He's that guy. And so I think it makes sense, because for a lot of courts, and I think you talked about this before as well, they don't see this level of DNA analysis from a day-to-day perspective. So having that guy come in and explain why it's so important, what you need to be able to properly cross-examine, I think really paints a good picture for the judge.
So I guess the argument would be, and I know you've said that you think the prosecution should turn all of this over to the defense. I would assume their argument would be that may compromise some of the investigative methods from investigators like the FBI, and maybe there's privacy issues as well, and maybe the defense shouldn't have access to everything. What do you think?
Well, I think this guy is not only that guy, I think what he said makes sense. This is evidence that could be exculpatory evidence, and it's evidence that the defense has to have to defend their client. It may reveal some information the prosecution doesn't want to be revealed, but the bottom line is, if this can help the defense, what if it turns out that there was a procedure that was done faulty, and it turns out that the defense could have gotten an expert to talk about that, and it's hurting the defense team. And while, you know, obviously we do want for this to be the right defendant, and we do want for this case to conclude, if it is wrong, we ought to know that from the beginning. And I think they should turn over what they have.
Real quick, the fact that the judge is allowing this to be heard seems like he's open to it.
Open to it. Also, you don't have to give all the information to everyone. You can do what's called an eyes-only release. So only the attorneys see this information so they can probably defend their client.
I think the judge is going to allow the defense to see it, but that's my guess. But we have a lot more to talk about with this. So coming up on Law and Crime Daily, we are continuing our legal analysis of Bryan Kohberger's motions hearing as we inch closer to a possible trial. The defense recently claimed that the grand jury proceedings were flawed, and now the prosecution is responding. Their argument that the charges against Bryan Kohberger are sound. That's next. And welcome back to Law and Crime Daily, everybody. We are continuing our deep dive into a motions hearing for Bryan Kohberger, the man accused of brutally stabbing 4 University of Idaho students to death. Another argument addressed in court on Friday was over the grand jury indictment. At the end of July, Kohberger's lawyers filed a motion to dismiss that indictment, saying the jury was misled about the standard of proof. The defense attorneys say the jury should have been instructed that they needed proof beyond a reasonable doubt that Bryan Kohberger was the killer in order for him to go to trial. Now, traditionally, grand juries have a much lower standard of proof to push through an indictment. In a response filed this week, the state called that theory jarring and said that the Idaho Supreme Court has said in other cases that the grand jury is used to determine probable cause. The defense also wanted to discuss allegations of juror bias, juror questionnaires that were missing some information, and some apparent violations because of how jurors actually answered some of the questions before being selected to serve. So, Terry, probable cause is the standard that we've always known. That's, you heard what the prosecution fired back. Who's going to win that argument?
Oh, I think it's going to be probable cause. I don't think it's going to be the higher standard. You have grand juries in every state, and most of the states do use grand jury processes under certain circumstances. And in all of those states, it is the fact that it's a lower standard. It's just to bring the charges against the defendant, to bring the indictment. And so I think that the prosecution in this case is going to basically, it's going to be the grand jury, probable cause. It's not going to be beyond.
Meaning it's fine, it's going to go through.
It's fine, it's going to go through.
Well,
now, the statute's not written properly. I think they need to clarify that.
So that's the question.
They do.
After this came out, I looked at it, and apparently in Idaho, there is not like a clear consensus. I thought that this was going to be one response from the prosecution, be like, what are you talking about? Look at X, Y, and Z. Even in their response, they're like, basically, even if there's ambiguity here, it's the Supreme Court that holds. I'm shocked that it took this case for there to be a spotlight on it. I mean, there was some discussion about this before, but they've always gone the probable cause route. What do you take away from it?
So I think it's unfortunately going to take us back to our first year of law school, where a statute says one thing, but the courts have always interpreted it as something else.
Right.
And so it comes down to one side wants to say the way the legislature wrote the law, and legislators write, we argue, it says it's the same standard by which you would have to get a conviction, which we all know is proof beyond a reasonable doubt. But the Supreme Court of Idaho has always said it is something else. And I think what has to happen is the legislature has to go back and finally get these two sides to stop squabbling like children and say, you know what, guys, we're going to put it all in the same boat. We're going to have the statute reflect what the law says, because ultimately, if this judge does say, yeah, the statute is correct, this doesn't get appealed to whoever wrote the statute. It gets appealed to the Supreme Court of Idaho, who's already said this is the rule.
And there was language like it would warrant a conviction. The prosecution was like, that means you could authorize it, but doesn't mean it's like two different standards. Real quick, you think the legislature is going to change this now that this became so high profile?
Probably, because they want to make sure that everyone understands what the standard is. And obviously, it's not even logical to have a standard beyond a reasonable doubt, because then why would you even have a trial?
I'll just say this much. I thought it was an interesting legal argument. From a lawyer perspective, I hadn't heard it before, but I think the prosecution is going to win the day on that one. All right.